Call the July 2, 2024 JPS meeting to order. I'm in charge. Me and General Hay. Anyway, Sally, if you go call the roll.
Vice Chair Eckhoff,
Here.
Member Chaplin, Member Childress, Member Desart, Chair Evans, Member Guston, Member Krajewski, Member Ozog, Member Schwarzy, Member Tornatori, Member Yu. Here. Member Zay.
Okay, we have a quorum. I'll entertain a motion to permit those members not physically present due to personal illness or disability, employment purposes, or the business of the board, family, or other emergency or unexpected childcare obligations to participate by video or teleconference. I have a motion, a second. Who made the motion? Sir.
We need a roll call.
You want a roll call? No. All in favor?
Oh.
Opposed? Okay, that passes. Chairwoman Evans is on a fact-finding mission somewhere in the world, so we will proceed without her today. Is there I have no comments. Is there a motion for the approval of minutes? Moved in second to approve the minutes of the June 18, 2024 meeting. Any corrections, comments? Hearing none, all in favor say aye. Opposed? That passes. Is there a motion to approve JPS 19-24, recommendation for the approval of contract purchase order issued to Cloud Gavel LLC for the implementation and annual service of warrant management systems for the Sheriff's Office for the period July 10, 2024 through July 9, 2029. Moved in second. Any questions or comments, Ms. Desart?
Thank you, Chair Eckhoff. I did have questions about this one. Could somebody explain what it is? And also I see that this is for 5 years. Is the 652,500 for 5 years or individual years? Can anybody explain what Cloud Gavel is? Thank you so much.
This is a warrant management system. Currently, the system that we have is set up with, it was designed with county IT. They've been running it for many years. It's gotten to the point where it's not feasible to be run anymore.
Yeah, so what does the system do?
The system manages all of our current warrants. So over 50,000 warrants for the county are stored there. The system manages it. We serve them. When they're issued, they're entered.
This is the criminal arrest warrants and body writs.
Correct.
And I see that there's a line item for training, but there is no number on there for training. So is training part of the fee or is that an extra?
Training is going to be part of the implementation fee. The implementation is going to be $200,000 for the first year. That also includes the first year of service. And then the following years after that, we've got just the annual service agreements.
Okay, thank you both. I just was curious about what it was. Thank you.
Ms. Garcia, did you have a question?
Thank you. I just wanted to say that in the absence of Anthony and Richard, who don't happen to be here at the moment, I'm just going to say that yes, this is an item that technology has been watching for a while. We know that this was going to happen. The whole reason why we were on the mainframe for such a long time is because we were waiting for this warrants management system. So now we're switching over, which is great. So thank you.
Thank you. Any other questions or comments? Hearing none, all in favor say aye. Opposed, that passes. Is there a motion to approve JPS 20-24 recommendation for the approval of contract to Laura McLaughlin as a recovery coach coordinator to work with Serenity House and Path to Recovery coaches, probation, and other stakeholders to provide services to the participants in the program from July 9, 2024 through July 8, 2025. Moved in second. Any questions or comments? You.
Thank you. My quick question is, how many clients or people that would Ms. McLaughlin work with? And are there outcomes of, increasing the number of people she works with, or is that part of the plan?
Well, we have an answer.
Good morning. Laura McLaughlin will be kind of like the supervisor of the recovery coaches. We have about 15 recovery coaches that work with our drug court and veteran court participants. And anyone in the drug court or veterans court are eligible to participate in the program.
Any other questions or comments? Hearing none, all in favor, say aye. Opposed? It passes. Moving on to FIR 113-24. Is there a motion for the acceptance and appropriation of Illinois Department of Children and Family Services Children's Advocacy Center grant in the amount of $346,127? Moved in second. Any questions or comments regarding this agenda item? Hearing none, all in favor, all say aye. Opposed? That passes. Moving on, is there a motion to approve FIR 114-24, acceptance and appropriation of the Victims of Crime Act Child Advocacy Center Services Program grant fiscal year 2025 in the amount of $67,740. Moved in second. Any questions or comments? Hearing none, all in favor say aye. Opposed? That passes. FIR, is there a motion to approve FIR 115-24, acceptance and appropriation of the Illinois Family Violence Coordinating Council grant in the amount of $49,000. Moved in second. Any questions or comments? Hearing none, all in favor say aye. Opposed? That passes. Is there a motion to approve FIR 117-24, acceptance and appropriation of the Tobacco Enforcement Program grant? And I'm assuming in the amount of $7,172. Moved in second. Any questions or comments? Hearing none, all in favor say aye. Opposed? That passes. Is there a motion to approve FIR 118-24, acceptance and appropriation of the Donated Funds Initiative Programs grant in the amount of $103,119. Moved in second. Any questions or comments? Hearing none, all in favor say aye. Opposed? That passes. Is there a motion for budget transfer 24-1900, transfer funds from the rental of office space to the account for building leases in the amount of $124,580 due to new accounting treatment for lease? Moved in second. Any questions or comments? Hearing none, all in favor say aye. Opposed? That passes. Is there a motion to receive and place on file 24-1887, Public Defender's Monthly Statistical Report for May 2024? Moved in second. Any questions or comments? Hearing none, all in favor say aye. Opposed? That passes. Moving on to our presentations, we have the Office of Homeland Security and Emergency Management for the fiscal year 2025 budget transportation by Director Mr. Diekman.
Good morning, Vice Chair Eckhoff and members of the County Board. The slide deck that we have up will be sent to you following this meeting. The Office of Homeland Security and Emergency Management has two components. One is Homeland Security and Emergency Management. Next slide, please. Homeland Security and Emergency Management, and the other is Campus Security. I'll present on both. Together, the FY25 consolidated budget request is 1% less than in FY24. Next slide, please. First, we'll start with the Homeland Security and Emergency Management side of our operations. Reimbursements are $84,400 less than FY24 for two reasons, which I'll explain in a moment. While the balance of the variance is due to the annual salary increase and items for which we are now charged as budget neutral expenses. Next slide. The only reimbursements OHSEM gets are from the Emergency Management Performance Grant, or EMPG, which all Illinois counties and accredited jurisdictions receive annually based on population and meeting certain state mandated criteria. It is reduced in FY25 for three reasons. First, our budget is prepared months before we know how much will be awarded in federal preparedness grants. We've typically allocated the same amount per year, and then we find out a few months later what we'll actually get. Second, for the past few years, the state has provided extra funding, which it calls the fifth quarter, that ended this fiscal year. And lastly, federal preparedness grant funding was reduced by 9% for the coming fiscal year across all federal preparedness grant programs. Those three factors result in an $85,000 reduction in our budgeted amount. Next slide. On our expenses, salaries have a 2.8% variance due to the COLA increase last December and reclassification of one employee to better represent the department's needs. The balance of the variance is due to budget neutral items for which the department is now charged, such as cellular service, copier lease and usage, and vehicle repairs. Now I will review the campus security budget request. Next slide. Campus security is requesting 11.7% less than in FY '25, and this is due to a few items. Next slide. Due to increased security coverage at some facilities, reimbursements are up by about $302,000. Of course, so is the security expense offset. A decrease in our request of $131,000 from last year is due to one-time FY '24 programs for alarm panel replacements and security coverage. The alarm panel replacements, the extra amount that we had in FY '24 will not be needed in FY '25. And the security coverage that was a new program last year is now rolled into the main security services account. We also saw a slight decrease in salaries and a slight increase in our our alarm software license fee. As with the HSEM portion of our budget request, campus security also saw an increase in budget neutral items for cellular service and copier usage. Next slide. This is a consolidated view of both components of OHSEM. Again, the FY '25 budget request is 1% less than for FY '24. As for our FY '24 expenses, we anticipate finishing as budgeted. Where our budgeted amount exceeds year-to-date actuals, there are three explanations. First, we have 5 months remaining in the fiscal year, and items that are consumed monthly, such as office supplies, will continue to be purchased throughout the balance of the year. Second, some budgeted expenses have not yet to be billed, but they will be. And then third, expenses for some accounts, like equipment and vehicle repair, were budgeted based on a 3-year historical average, but we just don't know yet if items will break or even need repair. And with that, are there any questions?
Mr. Krzyzewski?
Yeah, thank you. And I know you said you're gonna send us this tonight. We're 1% below, I guess, budget. We're looking at getting budget to budget. Aren't we gonna get presentations where we get the form that that Jeff gets us, that like we saw last week with travel and with all the other ones, where we can see the historicals? I mean, it's 1 page and it's the actual.
Those, Jason?
I'd like to have Jeff. I mean, can't we see like 21, 22, that the budget, the actual for
Remember-
each line item?
Great question. Member Kruger, I think on Friday, I believe I sent that email that had the full budget reports on that had the last 2 years. However, if you're looking for more than just that,
I wanna
OpenGov is
see
a good
the-
one, but I'll defer to what Jeff.
Just exactly
is
what
on
Jeff
that one.
gave us for travel the last 4 years, the exact same thing he. Yeah, but is that the last 4 years or is that just 2? Is that 4 years? Okay. Okay, I didn't see that.
Yeah, that was sent to you.
Okay. But and then the last thing was then but that just shows the actuals.
So you're looking for the
Actual,
broader.
the budget, the actual, because then you can see where the budget amounts and what they look to the actuals.
Then I
'Cause
will.
you just gave us actual, but we don't know what the budget was.
Say, hold on, let me look at this one more time.
I mean, this says actual 21, actual 22, actual 23, budgeted 24.
Get all that out.
Sent the worksheets that produced these looking. Sent them this evening.
So,
They're right.
Member Krajewski, if I'm just, what was sent was the FY '25 department requests, the FY '24 actual current, and then the 23, 22, 21, but you're looking for.
Well, but it was 23, 22, 21 actual.
Yes, so you want the budget,
I
not
want
the
to see
actual.
I want to see what they budgeted and then what our actual
Okay.
amounts were for each of those years, similar to what we got.
Sure. So you want a couple
Correct.
extra columns, understood. I will talk to the budget team about that and we'll ensure for moving forward.
Because that way you can see what we've been budgeting. I mean, and some of them, Jeff has pointed out, they just carry the same number over from the budget every year. And I can't see that because I only see actual. So I want to just,
And I do know I know OpenGov has a wonderful thing
it's
that
the
has all
exact same
that,
thing.
but
He gave us
no,
a
well-
report last week of like 7 different categories: professional services, IT, and he showed the budget, actual.
Jennifer
last 4
Sin just
years.
messaged me, said she'll get the reports updated based off what you're asking for, so we can do that.
Because I think that makes it easier for us to look at, because we can see how much below every year we've been below budget, and then when they request.
Yep, understood. Yeah, we'll do that moving forward with the rest of them.
Thank
You know,
you.
this is our first presentation of the year, so it's glad to hear the feedback and we'll go forward with that.
No, like I said, the ones that we got for travel, and then we had like 6 other categories that was multi-millions. of
All right,
dollars.
any other questions? We've got one other presentation. we gotta get
I
to.
know, real quick question is, are you gonna be doing any security, people in the judicial building going forward? I know that's been a sheriff thing, but I know that they're shorthanded and I know that we've had some issues there and I didn't know whether that was gonna be something with our security team.
I think Nick can comment on that.
That would not fall under the purview of Craig and his team. That's
Okay.
entirely a sheriff. They have control of that building.
Okay, I wasn't sure because they said other buildings and stuff, so, okay, thanks, Nick.
All right, if we can move on to our next presentation, domestic violence statistical update by our state's attorney, Mr. Berlin. Get the button there. They're leaving.
Good morning, everybody. Better? Okay, what I want to do this morning is kind of give you a before, an after, and where we're at since September 18th, 2023, the first day that the Pretrial Fairness Act portion of the Safety Act went into effect. So we're going to be talking exclusively about domestic battery cases, both domestic battery bodily harm and domestic battery insulting or provoking conduct, both of which are detainable offenses under the dangerousness standard. So just a refresher, in order to detain someone, the state first has to file a petition to detain, and the state has to prove 3 elements by clear and convincing evidence. The first being that the proof is evident or the presumption great that the defendant has committed a qualifying offense. Secondly, that the defendant poses a real and present threat to the safety of any person, persons, or the community. And third, that there's no condition or combination of conditions that can mitigate that real and present threat to the safety of any person, persons, or the community. All of the second and third also apply to willful flight as well. So if we look at our domestic battery cases, these are cases where a petition was filed. And this first slide here deals with September 18th, 2023 through April 28th, 2024. On April 28th is when we instituted our new policy. And so everyone's clear what the new policy is we added a person to our screening unit, and we also added an assistant on a rotating basis to first appearance court on the weekends. By doing that, we now have the police calling all domestic battery cases in, not for felony approval, but they're calling in what we call a domestic violence intake. And they are providing all this additional information, not only about the case, but about the offender's background. They do that 24 hours a day so that we can then get that information, put it in a petition, and have it ready to go by 8:30 in the morning. So the assistant that's working overnight will start the petition with that information. Our assistants that show up for first appearance court get here about 6:30 in the morning, and they get those petitions ready to go by 8:30. Some days we have more than 20 petitions on file, ready to go at 8:30 in the morning. So prior to April 28th, it was 34% of bodily harm cases that we were filing petitions on, 31.5% of the physical contact cases, and 46% of our violations of order of protection. Since April 29th, and this goes through last week, June 25th, we're now filing on 94% of all the bodily harm cases, which is pretty much almost every case. 81% of the physical contact cases, and on the violations of order of protection, we have filed on 100%. Here's the before and after statistics for detention. So this is now September 18th through April 28th. And you can see that for the bodily harm cases, 39% of those were granted. 36% of the physical contact cases, and the total of all the domestic battery cases was 38% for that period, September 18th through April 28th. Since that date, as I said, you can see we're filing a lot more petitions. As a result, those percentages of detention have gone down. 22.6% for bodily harm cases and 18.5% for the physical contact cases, for a total of 21%. And again, go back to where we were, it was 38% that were being granted, now 21%. Now, this is the percentage of petitions to detain in all domestic battery cases. So if you add up the bodily harm and the physical or insulting contact cases, a total of 275 petitions were filed prior to or through April 28th, with that 38% being granted. And then after, it's 205 petitions, 43 granted for 21%. The total there on the bottom is all domestic battery cases from the first date of the Safety Act, September 18th, through June 25th. And we are at 30.6% of those petitions that have been granted. This next slide is the percentage of domestic battery cases where a petition is filed, all domestic battery cases. So again, for that first period, September 18th through April 28th, the total was 33% that we were filing on. Since that date, April 29th now through June 25th, where we're getting a lot more information from the police, we're filing on 88% of all the domestic battery cases. And now this is, if you take all domestic battery arrests, the total number of arrests, and this is the total number detained. It was 12.5% for that first period, September 18th through April 28th. Since that date, we're getting the judges more information. As a result, even though the percentages have gone down of who's being detained, the total in regards to how many have been arrested, we've gone up to 18.5% of all domestic battery cases have resulted in detention. And here's how DuPage County compares to the other 3 counties that have a dashboard. And let me just give a thank you to our Circuit Court Clerk, Candace Adams, and Kevin Vasky, who created this dashboard and update it pretty much every day. So we're able to get this information. But 13.8% of all domestic battery cases result in detention in DuPage County. On April 24th, Loyola published a study, Loyola University, and at that time, DuPage was at 12.4%. So since that date, we've gone up to 13.8%. But compared to our surrounding counties that also have a dashboard, you can see that we are ahead of all of them in terms of the percentage of who is getting detained. It's the policy that we put in place. We have an on-call schedule. So we have attorneys now, they're working Monday through Friday, obviously during the day, and they rotate shifts at night where they're on call for these domestic intake cases, as well as an on-call schedule where they're rotating first appearance court on the weekends to kind of ease the burden on the screening unit, which not only screens 24/7, but is responsible for showing up on the weekends for first appearance court. And everyone has stepped up to the plate in my office, and they're doing an outstanding job. And I think the numbers kind of speak for themselves as to how things have changed since we put that new policy into place.
Well, thank you. Any questions? Jose?
Thank you, Mr. Chairman. Bob, thank you. You had brought up, we had the presentation by the Circuit Court Clerk, Candace Adams, that showed the dashboard. At that time, we were surprised by the amount of domestic violence calls in DuPage County, the detained and not detained. But again, thank you for your work. We know it's a difficult situation going to, very difficult for law enforcement walking into that situation too. And, the things that you're doing, we just can applaud you for continuing to seek to get these people detained on these issues. So it's kind of a wake-up call for people in DuPage County to see the amount of domestic violence issues that we're having over that short period you show us. It's a lot. So we appreciate all your efforts and your staff and making those changes and continuing to work hard to make sure that these people who need to be detained are detained.
Thank you.
It's you.
Thank you. Did you call my name? Thank you. Thanks so much for this presentation, the follow-up. I truly appreciate how you guys have made changes over at the State's Attorney's Office to really address this issue. My questions actually have to do, I think I asked you this before, and I just wanted to kind of reiterate that you have been contacting the victims right after the incident occurs, of course, before first appearance hearing, and that you've been, and it's really the domestic violence advocates who've been contacting those victims. Is that right?
Yes, we're required to contact the victim and let them know about the first hearing, and that gets done in every single case. In some of the cases, they actually will show up in court. When they do, my attorneys will always speak to them before the hearing.
Okay. And I actually had a conversation with Family Shelter Service advocates, and they were going over their training that their domestic violence advocates receive. And as you know, they all receive the 40-hour DV certification that's required in Illinois to be a domestic violence advocate. I think I assumed that your domestic violence advocates also received that 40-hour certification. Is that the case?
The advocates that we have are victim witness advocates, so that they're not just exclusive for domestic violence. They're advocates on all cases, all violent cases where there's a victim. And they do receive training. I don't know if they've specifically had that 40-hour training. That's something I can check into and get back to you.
Okay, that would be great. Thank you.
Sir.
Thank you, Chair Eckhoff. I know that domestic violence situations are some of the most dangerous that law enforcement can walk into. So thank you all for your service. Thank you for your presentation, State's Attorney Berlin. My question is, and thank you for getting these numbers up. And I see that DuPage County is a leader in this. My concern is that these are domestic battery cases. So hands have been laid on the victim. And, 13.8%, 14% is good number, but a great number would be 100%. I'm just wondering what we can do to make sure more domestic battery accusers are detained until their victim is safe. You know what I mean? I mean, this is domestic battery. Hands have been laid on. I would be so afraid if I was one of those victims whose batterer was not incarcerated. Thank you.
If I can respond, I do know exactly what you mean, and what it comes down to is the law. The requirement that we prove by clear and convincing evidence that the defendant is a real and present threat to the victim or the community. But the third element, that there's no condition or conditions that can mitigate that threat. We have to prove it by clear and convincing evidence. That means that the most severe condition, which is electronic monitoring, is insufficient. So I think to improve the percentage, we need a change in the law. And if you look at the total percentages for all cases, detention, we're at about 40% of all our petitions. That's not just domestic battery, that's everything. That includes robberies, armed robberies, carjackings, murders. The state average, because the numbers just came out for the 75 counties where they have pretrial services through the Administrative Office of Illinois Courts, is about 63%. Now, we're McHenry, Kane, Cook County are all hovering around that 40%. Actually, Cook's higher because they don't file as many petitions. The reason that we're lower than the state average total is because we file a lot more petitions. We file petitions in all cases where we think we can meet our burden of that clear and convincing evidence. But ultimately, it's the law.
And I do appreciate that. And I get all of your press releases. So I appreciate that not just domestic violence or domestic battery issues, but across the board, you are filing so many to detain the perpetrator. I really appreciate your efforts in that. Thank you.
Thank you.
Justin?
Thank you. Quick question. You are talking about the law, and I'm assuming, correct me if I'm wrong, this changed due to the Safety Act? And is there a way in which we can modify the law moving forward to have some additional criteria by which the judges can make a determination on detaining or not, particularly, well, in all cases, obviously, where there's a victim? Do you see that there is some opportunity for us to assist and have some of the law be modified in such a way to be able to get those percentages to 100%, something higher?
It's a great question. I have, since the beginning of the Safety Act, been advocating for the New Jersey model. And New Jersey gives judges unbridled discretion in all criminal cases to detain a defendant if that burden is met. And their burden is very similar to Illinois' in terms of what we have to prove. So if we give judges more discretion, that will result in more detention. But there's also, in regards just to domestic battery cases, there is a bill pending, Senate Bill 3947, sponsored by Senator Curran, which changes the standard, the presumption on domestic battery cases, where there would be a presumption of detention, similar to a change that New Jersey made after they eliminated cash bail. They changed their presumption on what they call the Graves Act cases. Those are cases where their offenses committed with a gun. Most of their gun offenses now, there's a presumption of detention. And they did that in 2022. And that has resulted in more violent offenders being detained. So yes, it's something that we continue to work on. We've had preliminary discussions with legislative leaders, but so far we haven't been able to advance any real changes.
Maybe we could do so moving forward. And I do want to say, your victim advocate individuals are phenomenal. Unfortunately, I've been a victim, so I've been in the process, and I do want to just say that they're very responsive, and I want to just thank your department for that. So
Thank you.
Mr. Schwarzy. Saw it. I saw you first. All right, Ms. Chaplin. You're muted. Words have been answered. You're still muted.
Okay, okay, yeah, they had me muted, so, okay. Thank you so much, Bob, for coming in and giving the presentation. And as we talk about statistics and, having people held for domestic violence, which I totally support. Prior to the Safety Act, how many of those domestic battery people charged with domestic battery were released on bond, and how many stayed in jail compared? I think that we have more people now staying in jail before their court date than prior to the Safety Act, but I could be wrong. But I thought because a lot of them were released on bail.
For domestic battery, it's a
Yes.
Class B misdemeanor. I don't have the numbers, but there's no question we have more being detained. Typically, prior to September 18th, when we had cash bond, your typical bond on a domestic battery would be $15,000, $20,000, or $30,000, where you have to post 10%. Most of those defendants were posting bond and getting out. Judges did not have the ability to set a no bond on a misdemeanor domestic battery. So no question, for that offense, we're seeing more detained.
So we've made a little bit of improvement. So, but what you're saying, if we can have legislation going forward, that would really solidify or improve what we already approved upon, correct?
No question. It's something
Okay.
I've been advocating for.
Okay, great. Thank you so much.
As you.
Thank you. So I actually asked you this before, but okay, so going back to the 832 arrests, you said that from September 18, 2023 through April, there were 832 arrests and 104 were detained. And it's a very large number for that period of time. And I'm wondering if there are any repeat offenders. And if there were repeat arrests, if that changed the argument going forward with the petition to detain, if that increased the chances, obviously, of the person being detained.
I don't have the number of repeat offenders, but there's no question. I can tell you that, yes, if someone's a repeat offender, it does increase the chances, the likelihood that they're going to be detained.
Mm-hmm.
And if they reoffend while they are on pretrial release, in addition to filing a petition to detain in the new case, we file a petition to revoke their pretrial release in the existing case.
Mm-hmm.
Oftentimes, one of the anomalies in the law is you can commit a new offense when you're on release, and the new offense may not be detainable. So we'll get conditions on the new offense.
Okay.
But then the judge on the original case will revoke pretrial release based on the new offense.
I see. And may I ask another question?
I guess.
Thank you. So we talked about partner abuse intervention programs, the PAPE programs, and whether or not that can actually ever be used more going forward. Because if there are those repeat offenders, and there's a 26 domestic violence, partner intervention class, if that is a possibility that we can increase, participation in those programs. Because if there is repeat offenders, there are repeat arrests, and this is something that's going to just keep continuing. And there is a cycle of domestic violence as well. So I'm hoping that you will also take a greater look at the PAPE programs.
I've been a huge proponent. Our office has been a huge proponent of the 26-week domestic violence class. And yes, we try and use that as often as possible. The challenge that our office and all state's attorneys' offices across the state continue to face is cooperation with our victims. In a lot of these cases, we struggle to get them to come to court when it's set for trial.
Mhm.
And to your point, yes, that repeats the cycle of domestic violence. We do everything we can to get them into court. And there's a lot of controversy over the idea of serving them with a subpoena and then enforcing that subpoena with contempt.
Right.
On a domestic violence victim.
Right.
There are some prosecutors who are okay with that.
Yeah.
Some think it's a bad
No, you
idea.
don't want to make them a
So
hostile.
it's
witness,
just,
right.
it's a challenge, but we continue to do everything we can. One of the things we have done in training our police officers on these cases is if we have enough evidence to proceed even without the victim's cooperation, we will go forward.
Mhm.
And so one of the requirements, for instance, is a written or a recorded statement, which we can use if the victim shows up and as substantive evidence, if it's contrary to the testimony that they give in court.
I have one more question if nobody else does.
Mr. Tornatore does.
Oh, thank you, Member Tornatore. My last question is, can you start changing the GPS monitoring requirements? Because of the last Villa Park murder suicide, I think it was 500 feet that the GPS monitor was supposed to go off on, and it wasn't enough time for police officers or for law enforcement to arrive. And as you stated, this is something that's been an issue. If there are conditions that would mean that, you know, the judge wouldn't detain, GPS monitoring being the big one, is it possible that we can change the policy to increase the amount of feet?
Yeah, so we did have a meeting with probation, with the chief judge to discuss changing it to right, 5,000 feet. Yeah, so it has happened, 5,000 feet. It's still, you know, that's still not a lot of time. It certainly will hopefully improve outcomes. The Villa Park case, the police actually got there within, I think, 3 minutes.
Mr. Tornatore.
Thanks, Bob. Your office is doing a great job, and I think to remember to Sart's point about getting it to 100%. Still have to remember there's a presumption of innocence in this country, and you got to remember that these defendants who are coming in, who are accused of this, aren't just admitting that they committed the offense of domestic violence. Many of them are saying, I didn't do it. So you can't get to 100% by virtue of that. And I think it's really important to remember the condition part that you talked about, that even when there's not a detention, there are significant conditions placed upon the people who are accused, which is the next best thing to detention. And you use those in what, did you say 40% of the cases or something? That number makes it all.
Well, the cases that do not result in detention, all of them have, the other ones all have conditions.
I have conditions, so it's
60%.
It's the best case scenario you can get under those circumstances, but great job.
Thank you.
All right, any other questions? Thank you, Mr. Berlin. Appreciate it. All right, moving on to old business. Is there, Mr. Sart, for old business?
Yeah, thank you. I know that we're running long, but I just wanted to say, give a shout out to the coroner, Dr. Jorgensen, and to the Deputy Director, Chris Haas of the DuPage County Health Department. We had a District 5 meeting on Friday and they both came and presented. And I think that's important for our municipalities to hear from some of our experts. So I thank them both. Thank you.
Okay. Thank you. Any other old business? Any new business? Chaplain, you don't have an announcement you wanted to make? Okay. All right. Move the second for adjournment. All in favor, say aye. We're adjourned.